Genetic resources is a slightly different issue, and I'll explain why shortly. On this issue, we have 2 or 3 different texts. One is a draft objectives and principles, dealing with 4 or 5 objectives and principles to do with IP, not just patents, but IP and what we call GRs. There is a textual proposal on a proposed mandatory disclosure requirement. For those of you who are not familiar with that, what that refers to is a suggestion that applications for patents and perhaps other IP rights in where the invention concerned is derived from a biological resource and associated traditional knowledge ought to enclose or include information such as that the prior informed consent of the state and or of the indigenous people has been obtained for the making of the invention, that mutually agreed terms were reached with the state again and or the people concerned, and that there has been benefit sharing, and it should disclose, of course, the source of the resource and of the knowledge that was used. And thirdly, on this item, there are also proposals, there's one from Japan in particular, that databases would be very useful in this area. I'll come back to that again shortly. In respect of TK and TCEs, there are a number of difficult questions, but we can simplify them down to 3 main ones. What is traditional knowledge? What is a traditional cultural expression as opposed to a cultural expression? I mean, is the music from, you have to remind me the name, Ida Reichel? Yes, that's tradition-based. It's derived from tradition. Is that a traditional cultural expression or simply a copyrightable work protected under the conventional contemporary IP system? Difficult issue here is what to do with publicly available traditional knowledge. Most of TK is publicly available, and it's in databases and textbooks and etc. And it has, the horse has bolted in a sense, and what does one do to recover that if one should? Secondly, who should the beneficiaries be? Sharon has very ably touched on that, the difficult question of nations. I won't go into that. And of course the how, so the what, the who, and the how. And in terms of the how, very tricky question is whether an exclusive rights approach is appropriate in this area, or sometimes also the term used is free, prior, and informed consent. In other words, should one give indigenous peoples or TK holders or custodians the right to say no prior to the use of the TK or folklore by a third party? Genetic resources are not intellectual property. They, as found in nature, they're not the result of the human mind, and in fact this subject is not dealt with by Wipo at all. Access to and the regulation of use of GRs is covered by the Convention on Biological Diversity, the CBD, the Nagoya Protocol, which is in square brackets because it's not yet in force, and the FAO's international treaty. But for intellectual property, there are 2 issues. One is a quality of patent examination issue, and that is to do with the, and I think I would say that there's universal agreement on the need to prevent the granting of erroneous patents. So this is patents of inventions that are derived from a genetic resource and associated TK, but that are not novel or sufficiently inventive in order to be patentable, and that's the one issue. The second issue is to do with the mutual supportiveness of intellectual property systems with the achievement of the goals of the CBD. And here we get back to the proposal of the disclosure requirement. And that proposal is essentially nothing to do with improving the patent system itself. It's rather to do with using the patent system as a source of information to track uses of GRs and TK in order to better implement the CBD. And the people who resist that proposal will argue that countries that have ratified the CBD, which is 99.9% of countries, are obliged to enact access and benefit sharing legislation at the national level, and that is the way you implement the CBD. You don't use the patent system because it's an existing functioning system. You don't use that as a sort of backdoor to implementing the CBD. On the other hand, as I said before, I do think it'll be extremely useful and good if the IP system was seen to be supportive of other policy areas and other policy systems. What kind of system might there be? And I think it's useful to think about what kinds of objectives one could have in mind, and previous speakers have had their own lists, and I think our lists are very similar in many ways. I think that acknowledgement and benefit sharing must form part of a model. Acknowledgement of the ingenuity of indigenous peoples. This is about the respect part, and the reward part is the benefit sharing. There must be some sort of benefit sharing if the TK in its raw form has been cooked by a third party and benefits have derived from that. The promotion of innovation must be, from an intellectual property point of view, one of the key objectives that should form part of the model. Equitable access to the benefits of that innovation, the sharing idea, must also be part of the model. The public domain is important, and it's not an exception to the copyright system or to the IP system. It's part of the IP system. It's an important part of the IP system, and a robust public domain. The commons, as it's also sometimes referred to, different concepts slightly, but that is again an important building block in the system. And finally, whatever model the member states agree on should be implementable in practice, something that is not undoable and unworkable in practice. The trend is towards, and the draft articles that are being negotiated at the moment, both on traditional knowledge and on folklore, because there's two different texts, are tending towards an exclusive rights approach. And as I've indicated before, I think that there are difficulties with that approach if one measures that against the other goals of innovation, a robust public domain, practical implementability. What other models are there? Schubert's already mentioned actually the compensatory liability scheme proposed by Reichman and Lewis. This introduces a kind of semi-commons where one might, again to use the raw and cooked terms, that the raw TK cannot be duplicated by a second comer, by a third party, but a second comer is able to encourage to improve upon the raw TK and improve upon it, and in that case would have to compensate the original TK holder. It's an interesting model. I think it does strike many of the balances that are necessary. The FAO's international treaty is another model worth looking at. I won't go into all of these in great detail. The Pacific Model Law on TK and TCEs is also, I think, worth looking at. That's a model which does not actually always provide for an exclusive right or the right of prior informed consent, encourages second comers to create on the basis of the TK and the folklore, but has a very strong moral rights component to it. The right to acknowledge the source of the TK and the right not to make offensive use of the TK. And interestingly, that is also the direction taken in New Zealand recently. You might be familiar with the Waitangi Tribunal process. Some of you are. And this tribunal came out with its report just a few weeks or months ago. And it also, after more than 10 years of consideration of this question in New Zealand, has sort of come on the side of a more moral rights approach to TK and TCs and not an exclusive right. The WHO legal framework on the sharing of viruses, of the influenza, the H5N1 virus, is another interesting model that one might be able to draw from. In that model, of course it's a different context, but nonetheless it's an interesting model. Member states that are rich, in quotes, in the viruses, in the influenza virus, are obliged to share that with the WHO, and which in turn will provide that to pharmaceutical companies that can develop vaccines and drugs and diagnostic tools on the basis of the virus, and when that happens, that they're free to patent the products or the processes which are derived from that. But in that case, the companies must grant a royalty-free, a non-exclusive royalty-free license to the country that provided the virus, so the country can, again, on the basis of that, improve upon the technologies that were patented before. And I think that's the kind of approach and the kind of model that will work very well in the TKGR and TCE area. Finally, the IGC meets only 3 more times before next September. There's a session dedicated to GRs. It's an 8-day session, especially long because of the importance of this item. It was this item that led to the creation of the IGC in the first place, and this item is the most important and the most difficult of the 3 themes. And then there's 2 other sessions on TK and TCEs, and then the Wipo member states meet again in September next year to decide on convening a diplomatic conference. And a diplomatic conference, as you probably all know, is the place at which member states finally negotiate and decide on a binding international treaty, which is what many countries want in this area. So in sum, the train has left the station. I'm relatively confident that there's a momentum now. There will be an international outcome in this area in the next few years. And again, as I said this morning, I'd encourage all of you to follow the work and participate with all of your different points of view in this process, which is an important one. Thank you very much.